Welcome to Trust and Estate Clarity with Dada Law Office.
Welcome to Trust and Estate Clarity with Dada Law Office and attorney Codi Dada, founder of the Dada Law Offices in Novato. Recognized as one of the top 10 best law firms in California, Codi focuses exclusively on estate planning, trust, and probate administration. I'm Lisa Mosbey, and today we're looking at one of the biggest practical questions in estate planning: what actually belongs in a living trust? What usually does not, and why getting that part wrong can create major problems later. Welcome, Codi. Thank you so much for joining me to discuss living trusts today.
Thank you, Lisa. Nice to be here.
Codi, how does someone know whether an asset is actually inside their living trust or not?
Well, that's a great question. And it's very important because that's what makes it all work. And the way to make sure that your asset is part of the trust is making sure that the title on that asset is titled in your name as trustee of your trust. So for real estate, that means the deed has to say on the deed recorded in the county that it's held by the trustee and list the name of the trust and the date of the trust. On bank accounts, very similar. On the account statement, where it says the account owner, it should say the trustee's name as trustee of the trust and the date of the trust. For other things like retirement accounts and life insurance and other qualified tax-deferred accounts, those are distributed to who's named as a beneficiary. So it's important that you review those beneficiary designations in the paperwork at the company that holds those accounts, because that's what has priority with those types of accounts, is who's listed as a beneficiary. So if you want your trust to go, if you want that asset to go to the trust, then you have to list your trust as a beneficiary of that account. Otherwise, you have to name individuals directly who would be able to receive those accounts directly from the company, and that would not go to the trust. So depending on the asset, there's a few ways to make sure that the assets are titled in the trust. Again, it's either title the ownership of that account or real estate into the trustee's name as trustee of that trust, or name the beneficiary.
And then what kinds of assets are commonly placed into a living trust in California?
Well, the most common assets are real estate, because real estate has no designated
Yeah.
beneficiary. So if the owner passes away, then the rest of the world doesn't know who's in charge of that property. And then we have to go through court to get someone legally authorized to manage that real estate. So definitely real estate should be in the name of the trust. Other accounts like your investment accounts, your checking accounts, savings accounts, those should also be part of the trust, entitled into the trust. And then depending on the circumstances, we would take a look at your retirement accounts and life insurance and look at your specific circumstances and determine whether it'd be more appropriate to name the trust as a beneficiary of those type of accounts, or just to simply name people directly to receive those assets. And that would depend on things like whether you want to control how the money is distributed after your life, whether the person who's receiving it is receiving government benefits or likely to need government benefits in the future, and also the tax bracket of the persons that you would like to give those assets to.
And Codi, I can honestly say the one that confuses me the most is insurance. Does that go directly to your spouse, to your beneficiaries? Does that go in the trust? So I'm curious, what are some assets people are surprised to learn usually do not get handled through a living trust?
One of the most common are retirement accounts. So those don't get titled in the name of the trust. Those are custodial accounts. So meaning that they're held for our benefit. We're the beneficiaries, but we're not supposed to get the money until we reach that certain age or we meet those certain requirements. So the way that the financial markets are designed is that those types of accounts, like retirement accounts, pensions, 401ks, IRAs, and life insurance, those are distributed to who's named as a beneficiary in the paperwork at the company that holds that account or that insurance policy. That's what has precedence. That's what has priority. So it's important that people align their designated beneficiaries with their intentions. Because if the trust says that they want a certain account to go to someone, but in reality, there's someone else named as a beneficiary, then there's a conflict and it's setting it up for possible arguments in the future. So if your circumstances warrant naming the trust as a beneficiary of those types of accounts, then certain language has to be included into your trust so that those accounts can easily be distributed to your children or who you've named as a beneficiary, while allowing that person, if they qualify, to stretch out the distributions for the maximum duration allowed by law. And so if you give it directly to a trust, there's different minimum required distributions versus giving it to a child or to a spouse. And depending on the circumstances, we take a look at their specific circumstances and advise the client how to name those beneficiaries or whether they should name the trust as a beneficiary.
And Cody, can you walk us through an example of what happens when someone has a trust, but important assets were never properly connected to it?
Well, that's unfortunate because that's where the problems arise. If you just have a nice set of documents and you don't properly fund the trust with your assets properly titled, then it creates a situation where we have to jump through a lot of different hoops depending on the size of the estate. Currently, if the estate is over 208,000, meaning the funds that are not in a trust, if there's more than 208,000, then we have to go through a court process called probate. And whether we can show intentions that that person wanted the assets to go to the trust or not would depend which process we would use to go to probate. So if there was minimal assets and there was a trust available and we could show language in the trust or with external documents that the person intended for that asset to be part of the trust, then we can go get a court order which would give us permission to directly transfer the assets to the trust. Now, if we don't have that kind of showing of the person's intentions, then we have to go through formal probate, which is a multi-step process. It takes anywhere from 9 to 18 months, and it costs tens of thousands of dollars. And that's what we want to avoid. That's why getting a trust is so important, because once you have your assets in a trust, probate is not required at all. And the point of a good estate plan is not only creating the trust, but again, making sure that the assets are properly connected to the trust by placing the title of the trust on the account ownership of that asset.
Can we talk about how different assets need to be handled differently when it comes to trust planning, especially things like real estate, bank accounts, investment accounts, or business interests?
Absolutely. Absolutely. So depending on the type of asset determines how the asset will be titled. So for real estate, it requires a deed, and then we have to record the deed with the county recorder's office. We have to file what's called a preliminary change of ownership. And sometimes, if the circumstances warrant, we have to file a change of ownership report. Those are public documents that get filed with the county where the property is located. Okay, now you have other assets like bank accounts, savings accounts, accounts, investment accounts. Those get retitled in that the person has to go to the company and ask the company to change the name on the account title to say the trustee's name and the name of the trust and the date that the trust was created. That's what gives permission for everyone else in the real world to follow the instructions of the trust without worrying about getting in trouble. and therefore they won't require anyone to go to court to get legally authorized to access that account. And then you have things like business interests. Those get a little bit more complicated because oftentimes LLCs have an operating agreement, corporations have bylaws, and the terms of those operating agreements or bylaws or partnership agreements will tell us how the asset can be distributed. Now, with business interests, we don't want them to be directly owned by the trust because part of having a business interest is protecting you in case something goes wrong in your business activities and a lawsuit arises. So we want to keep that as a separate entity. So if there are any legal problems, it's not part of the trust estate. But at the same time, we want to make sure that those business interests can easily be managed if something were to happen to the business owners. So what we typically do with those types of assets is we create an assignment of business interests that shows your intentions that if anything were to happen to you, that you would want all your benefit from that business to go to your trust. Equally as important is that the operating agreement and the bylaws of that business should reflect how you want the succession of that business to play out if something were to happen to you. And in an operating agreement, it should indicate if you're unable to manage the business, who is going to be able to step in and manage the business for you. That is the first document that the banks will go to if something were to happen to you and someone stepped in to try to access business accounts. The financial institution is going to pull up the operating agreement that you gave them when you opened up that business account or the bylaws. And they're going to look in there and they're going to find the information that tells them who's next in line. Now, the problem with most of these boilerplate operating agreements and bylaws is that it has some generic language that says that the successors will be chosen by the board of directors or by majority vote. But oftentimes these small businesses only have one owner or two owners. There is no board of directors. It's not formally organized. So if that person passes away, they may be the only one that has the authority to appoint a replacement. And if they're unable to appoint someone, then those bylaws just create ambiguity, and the banks now want us to go to court to straighten out the ambiguity and resolve the question of who gets access to this business account. So it's important that we go through the client's operating agreements and we ensure that that language is included, and we provide many levels of safety in that not only do we name actual people that would have the ability to step in, but we also reference the trust in the operating agreement so that as a all fails safety net, that the person in charge of the trust can step in easily and take control of the business interest, but only when needed after that person's life. During the time that the person is actually running the business, that business remains as a separate entity and is not necessarily owned by the trust to ensure that they are still protected in the event that litigation arises during their business activities. Let's see. I think that's about all the different types of assets. They're going to fall into one of those categories, either direct ownership, assignment of beneficial interest, or naming a beneficiary.
And the next step is to talk about those beneficiaries. Cody, how do beneficiary designations affect what happens to assets like retirement accounts or life insurance?
Well, that's what controls. So those types of accounts like retirement accounts, life insurance, 401ks, IRAs, pensions, those types of things are not controlled by a trust unless you name the trust as a beneficiary. What has priority with those types of accounts is who's named as a beneficiary in the paperwork at the company that holds that account, whether it's an IRA, 401k, pension, 529 plans. All those are designated to be distributed to who's ever named. Now, the problem is if there is no one named. Now, if you have those types of accounts and there's no one named as a beneficiary, then it creates uncertainty, and then that's where the possibility of probate comes in. If the account is over the 208,000, which is the smallest state limit as of 2026, right? Then we have to go through probate either to show your intentions that you wanted that account to be part of the trust, or through the full formal probate process. So what we advise our clients is that they make a list of all their accounts, which we do for them, and we go through one by one and we determine whether each asset would be part of the trust, or the trust would be designated as a beneficiary, or if they're going to name beneficiaries directly. And depending on the circumstances and the person's assets, we'll be able to tell them what would be appropriate for their situation.
And so, Cody, if someone already has a trust in place, how often should they be reviewing their assets to make sure everything is still lined up with the plan itself?
Yeah, that's a great question. A lot of times people, they just create these documents and they set them away in a closet and they never look at them again. And then when the time comes and they're actually needed, they find out that things weren't properly funded, that things have changed, and it's not what they really wanted at the time, but they never really thought about it. So it's a good idea every couple years to take a look at the trust and look at the key areas. You don't have to read every last page, but the key areas would be who's your backup people, right? If you weren't able to make your financial decisions, who is it that would have permission to step in and access your bank accounts and pay your bills? And then how are the assets going to be distributed after your life, right? During your life, everything's going to be for your benefit and for your comfort and enjoyment and health and maintenance. But after your life, sometimes people change their minds and they want to distribute to additional people or different people. So every couple years, or if major life changes happen, new births in the family, deaths in the family, marriages in the family, things like that would warrant going back and reviewing the estate plan and just refreshing your memory and making sure it's still the way that you would want it.
Wonderful. Thank you so much for walking us through the living trust process, the assets that need to be added and those that don't. I've enjoyed our time today, Cody. Thank you.
Thank you, Lisa.
Thank you for joining us for the Trust and Estate Clarity with Dada Law Office and attorney Codi Dada. Feel free to take a moment to subscribe, like, and share this episode with someone who needs to hear it. For more resources or to start your own plan today, visit dadalaw.com. Thank you so much for tuning in, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.